Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can a police officer search a minor without parental consent? This is a critical question for every parent and young person, and the answer is often a surprising yes, depending on the situation. The foundation of this issue is the Fourth Amendment of the U.S. Constitution, which protects all citizens, including minors, from unreasonable searches and seizures. Generally, this means police need a warrant to conduct a search. However, the law is filled with exceptions, and these exceptions are where things get complicated for minors. The most significant factor is consent. A police officer can ask a minor for permission to search them or their property, like a backpack or a car. If the minor agrees, the police generally do not need parental consent. The key legal question is whether the minor's consent was given voluntarily and intelligently. A court would look at the totality of the circumstances, which includes the minor's age, intelligence, education, and whether the officer made it clear that they had the right to refuse the search. The consent of a 17-year-old who understands their rights will be viewed very differently from the consent of a scared 12-year-old. Beyond consent, police can search a minor if they have probable cause to believe the minor has committed a crime and has evidence on their person or in their property. For example, if an officer stops a car driven by a teen and sees illegal drugs in plain view on the passenger seat, they have probable cause to search the rest of the vehicle without a warrant or consent. This is known as the plain view doctrine and the automobile exception. Another major exception is a search incident to a lawful arrest. If a minor is legally arrested, the police have the right to search their person and the area within their immediate control to check for weapons or evidence. Parental permission is not required in this scenario. The rules change dramatically when the search happens at school. The Supreme Court has ruled that students have a reduced expectation of privacy in a school setting. School officials, like principals or teachers, do not need probable cause to search a student. They only need reasonable suspicion, which is a much lower legal standard. This means they only need a moderate chance of finding evidence that the student has violated a school rule or the law. If a school official conducts a search based on reasonable suspicion and finds contraband, they can then involve the police. Because of these complexities, it's vital for young people to understand their rights. They have the right to say, "Officer, I do not consent to a search." They should always be respectful, but they can be firm in stating they do not consent. Teaching a minor to ask, "Am I free to leave?" is also important. If they are not free to leave, they have the right to remain silent and ask for a parent or a lawyer. Understanding these rules can make a significant difference in a stressful encounter with law enforcement. Thank you for watching and taking the time to learn about these important rights. If you found this video helpful, please give it a thumbs up and consider subscribing.